Hello, so today we're going to be talking about the EU Directive 2019-1158, so the work-life balance for parents and careers. So what is this EU Directive about? Well, what it strives to do is bring equality between men and women in the workplace. It tries to open up and create equal market opportunities and just help equalize the balance between men and women's representation within the workforce. It also tries to aid treatment at work and trying to balance out treatment of family members and carers who are currently living and working within the EU. They do this by easing parental unity with the family and with work. Before starting to talk about how it was adopted, I'm going to start talking about the rights that come along with this. So basically the rights are, it enforces paternity leave, parental leave, carer leave, and flexible working hours for parents and carers. Now, let's talk about its adoption. Its adoption can be found under Article 20 of the directive itself. Now, it means that it must be fully incorporated into a member state's legal system by December 2nd, 2020. Now, this means that it must pass a national statute and become part of the country's national laws in order for it to be succeeded. In the national laws, the directive must have reference in the article or in the piece of legislature in order it to be valid. And then it needs to be officially publicized in a gazette or in a journal, legal journal for it to be made aware to the public. By doing this, the statute or the directive then becomes a national statute and then it becomes applicable within the country. Now, I say that 3 years is a long time to adapt an article, but in this case, they need to put necessary provisions and also apply national ideas and change national legislation in order to combat any prejudice put forth by businesses towards the government.
Okay, so I will be explaining the first 3 articles of the directive. So first one is paternity leave, which is described in Article 3 as a leave for the purpose of providing care. This one involves fathers or what the national law of each member state recognizes as equivalent second parents in their national law. It grants a paternity leave of 10 working days, but it's pretty flexible because it grants discretion to each member state to decide if the leave be taken before or after the child is born. It is not subject to a period of work or length of service qualification, and this right is granted regardless the marital or family status that the worker has. Next is paternal leave, which is in Article 5, and this one is an individual right of each parent to a paternal leave of 4 months before a child reaches a specified age, which the maximum age is 8, but each member state can specify the age that they wish or by collective agreement of many states. You must give a reasonable period of notice, and this one is subject to a period of work qualification or length of service qualification, which has a maximum of 1 year. And the workers may request to postpone it if they have well-founded motives for it. And this one also grants discretion for each member state to decide which qualifications they want in order to grant this postponement. And finally, they, like parents with adoptive children or parents with disability or parents of children with disability or illness have an adaptation of the leave. And just to give an example of in Spain, the royal decree kind of makes a distinction between, because in Spain there's always been a distinction between men and women, so the fathers got less leave, but by 2021, this decree law intends to make the right equal and therefore non-transferable. Next, we have the carer's leave, which is provided for in Article 6. And it's described as a leave to provide personal care or support to relative or neighbor. And you get 5 working days per year, and each member state can decide the specific details regarding the scope and conditions of this leave. And finally, the time off from work on grounds of force majeure, which is provided for in Article 7, and each member state must ensure that basically each worker has the possibility to access this right for urgent family reasons, which could be illness or an accident.
So Article 8 is about payment or allowance, and essentially this article deals with the issue of payment during leave. It's already been established within the Parental Leave Directive of 2010. However, this directive didn't specify what the minimum requirement was for for what's considered an adequate allowance. So this Article 8 just kind of ensures that the minimum amount granted is the amount granted during sick leave, and that's supposed to be for every type of leave granted to a worker. Article 9 is the succeeding article, and it stipulates that working parents are allowed to create a more flexible work schedule. And again, an article in the Parental Leave Directive of 2010, they already allowed this, but it was only with 2 different types of flexible work arrangements, and that was flexible working patterns and then working hours. However, this new directive adds a 3rd one, which is remote working possibilities. And like the rest of these rights granted to parents, is essentially just to allow and incentivize parents to stay inside the labor market. Article 10 essentially ensures parents that their employment rights are protected and that they can exercise their rights to parental leave, right to return to the same or equivalent job. And this is also enforced within national law, collective agreements on practice, and everything else, all that applies. Article 11 is about discrimination, which ensures that workers that are parents are still protected from less favorable working standards.
So now we'll move on to Article 2, dealing with the protection and dismissal, just protection from dismissal and the burden of proof. So essentially, this article requires that the states must ensure that workers are not dismissed for the reasons above stated in Article 4, 5, and 6. And this would be the articles relating to paternity, paternal, and caregivers leave, as well for being dismissed for reasons for requesting flexible conditions under Article 9. Now, the burden of proof lies with the employer to prove that the dismissal is not because of the reasons given in Article 4, 5, 6, or 9. Article 13 outlines the penalties that member states must work to pass legislation which punishes infringements of the rules laid out in this provision. All right. Article 14 is the subject matter of which is the protection against adverse treatment of consequences. Now, the member states must ensure the protection from harassment caused by requesting leave as explained above, and they must be afforded the same treatment regardless of their position. Article 15 deals with equality bodies, which is essentially referring to government bodies that deal with equality. And so this applies competence to existing or new bodies that inspect for labor equality to carry out the provisions of this directive. Now, they will be able to deal with complaints regarding leave, as mentioned above, and they'll also be given competence in enforcing and prosecuting these infringements. Now, Article 16 outlines the levels of protection that the directive will allow. So this directive will allow only changes in favor of the workers, and it will not allow the directive to be used in a way that would limit workers' rights in the country. If they have more stringent measures, if the member state has more stringent measures, this directive does not allow them to backpedal, but they are allowed to keep those stricter measures.
Okay, now I'm going to talk about the EU Commission report. Sometimes the Commission realizes some reports based in the EU directive, because sometimes the directive is very broad, and what it does, the Commission, is do a comparative report with all the member states to know what exactly are the needs that the European Union needs to be regulated. So the first report is the family-friendly workplaces. As the directive is mentioned, we need to balance the professional and our family life. This report, what has mentioned, is that they carried in 2017 a survey, and more than 50% in each member state, the people said that they cannot balance their family and their work life. What happens if we don't have flexibility, if we don't have adequate social security that could carry, for example, nurseries for little kids or things like that? We cannot balance family and workplace. So the family-friendly workplace, they impose some measures, for example, using term time working, flex time, compressing hours in order to have family-friendly workplace and that all the people could balance their lives. This is really helpful since normally women are the ones that leave their job position in order to take care about their family. So having this workplace will allow women to be more in the workload, and also this will include that adults and children could carry out the activities. Also, this solution is included in the European Pillars of Social Rights. It's true that some member states, for example, the UK or the Netherlands, have carried out these flexibility clauses that said that for children up to 12 years, so in the case of the UK and the Netherlands, if you have someone under your responsibility, you can have these flexible times. Then the next report was the leave policies and practice for non-traditional families, since the directive is very broad and normally is the competence of the member states to decide how they impose the leave. For example, there are problems with adopted family, reconstructed family, and same-sex parents. As you can see here, normally the marriage from same-sex couples are only recognized in very little states. So, for example, in order to have legal parenthood rights, they are going to be limited in that state and not in the others. Also, if you can see here in this map, is that there are very little countries in the member states in the European Union that they have equally parental leave for all type of parents. So what the European Union said that in order the society is going to evolve, the directive or the transposed legislation of the member state must be applied to all type of families.
It has been 1 year after the directive came into effect, and the results are already coming to light. Now, the time period, which is 3 years for the states to implement it, hasn't expired, so the final results will still have to be seen. But for now, the Work-Life Balance Directive has been considered as one of the most important initiatives in the sphere of employment, because it reflects and it recognizes the realities of the 21st century family life. So, for example, the traditional roles have changed a lot. There have been many changes introduced with technology. And so this directive clearly represents all of these. However, these realities are already being challenged by the ongoing pandemic, as you might have known. So, for example, new challenges have emerged during this era, which make this directive more relevant than ever before. There are increasing problems with family life. There are more problems than ever with the private and work-life balance. And so, for example, the flexible work arrangements are more crucial than ever before, and the directive plays a crucial role. So this is a quote from the Parliament magazine, and it says that the directive has been a positive step towards accommodating a healthier life in a time when technology has brought work into our homes. So it is said that the pandemic will change work-life balance forever. So if anything, it has showed us that it is more important than ever before, because businesses don't work unless people do, and people don't work if they're not able to manage their lives. So the directive could be said that it is perfect timing, because it gives like possible options which employers can use and employees as well to adapt rapidly, but it has not always been negative. For instance, there is a greater feeling of control as people feel that they can manage and accommodate their time to this. But women, for example, are still impacted disproportionately. But however, this is being tackled, for example, with the introduction of the paternity leave or with the care leave, as the distribution of responsibilities is switched a bit. So overall, how does this directive affect labor law in general? So first, it's an introduction of new labor rights that we could say they're adapted to the 21st century. So for example, the right to request remote working. So it's basically restructuring how work is done. And the crisis, it has brought even more awareness than ever before. The scope of this directive is even bigger than the proponents ever imagined. And even the opponents have realized that it is beneficial for everyone. So it will be interesting to see what will happen in the following years to come, to see how countries will adapt it to the situation. But for instance, there's a different set of views or mentality that are now considered like antiquated. And so for instance, now it is considered unconstitutional for people to ask women whether they plan to have kids or not in the future. So in conclusion, the modernization of EU's legal and policy framework is beneficial overall. There is still a long way to go, but countries are already taking a lot of steps. So basically, this directive is more relevant than ever before, and it shows us how it is very crucial to get a balance between private life and work life, especially during these times.